and I know Minister Juliet Flynn, we were there together. And I know they're having a conference today and tomorrow. And Julia Wigan, representing the Ministry of Justice, is there today, and she will also be there tomorrow. But in her place, and really to present the overview, is Attorney at Law Sandalou Cole-Jarrett, and also with her is Venetia Clark, who is the Child Diversion Officer, Chief Child Diversion Officer at the Ministry of Justice. So they're going to help us out for the rest of the day. So without further ado, I'm going to ask Mrs. Sandalou Cole-Jarrett to continue. You recall where we stopped last time?
Yes,
what?
Minister. So good morning, committee members. If you recall from the last sitting, we would have started our clause-by-clause presentation of the Child Diversion Act. At the point where we had stopped, we had just went through the definitions under the Act under Part 1.
Okay.
And so we will pick up from there. We're still under Part 1, but we'll now move on to Section 2, so the actual sections of the legislation.
You want to tell us the page? I think members have your document too. Where are you now?
All right, so unfortunately there are no page numbers, but if you follow in the Act, we would actually be at page 6. So if you have a copy of the Act, we're on page 6 of the Child Diversion Act.
What page?
Minister, it might be more helpful to just indicate the section.
She's just looking at the document which we have. So in a short while, she will identify exactly where she's continuing from.
All right, so if you're looking at the clause-by-clause document that would have been submitted by the ministry, we would be at page 14.
Okay, so we are now at page 14. So we had started it on the last occasion, as members will recall. So we are now at page 14, looking at section 2.
Yes, Minister.
All right, continue now then.
Right, so section 2 indicates as follows. Where there is reference in this act to the best interest of the child, the factors to be taken into account in determining the best interest of the child shall include the safety of the child's physical, mental, and emotional needs and level of development, the importance of continuity in the child's care, the quality of the relationship the child has with the parent or guardian, and the effect of maintaining that relationship, the child's religious and spiritual views, the child's level of education and educational requirements, whether the child is of sufficient age and maturity so as to be capable of forming his own views, and if so, those views are to be given due weight in accordance with the age and maturity of the child, and H, the effect on the child of delay in making a decision. So these would have been the considerations to be taken into account when determining the best interest of the child. The ministry takes no issue with the current framing of the section, and so we had no recommendations. On to section 2.3, the act shall be interpreted and administered so that the best interest of the child is the paramount consideration and in accordance with the following principles. Criminal proceedings are not to be instituted against a child if there is an alternative, an appropriate means of dealing with the matters, and B, unless the public interest requires, and subject to this act, any child who has committed a diversion offense and accepts responsibility shall be considered for admission into a child diversion program. And the issue we have identified here at the ministry is that this section possibly conflicts with Section 9, because all that is required here is that the child accepts responsibility to be considered for admission into the child diversion program, according to B. But if you look under Section 9, which is a connecting clause somewhat, it has 4 requirements under that section. So apart from acceptance of responsibility, it would have consent and other factors. So the committee may want to look at Section 2.3 together with Section 9 to determine whether or not there's a conflict.
When we get to Section 9, we'll just have a discussion, okay?
Right. And the other conflict as well would be that B again says that the child shall be considered for child diversion once the child accepts responsibility, which suggesting by shall that it is mandatory. But again, under Section 9, the clause uses the reference may. Right. So Section 2.4 reads, an acceptance of responsibility by a child for a diversion offense is not acceptance, for the purposes of this act unless it takes place in the presence of the parent or guardian of the child, an adult other than a constable, who is present with the consent of 1, the parent or guardian of the child, or 2, if the child has attained the age of 14 years, the consent of the child. The issue identified by the ministry here is that in terms of the use of acceptance of responsibility, that is not defined in the act, or what the parameters under which this acceptance would be obtained from the child to be used as validity other than an authority being present. So the child is required to accept responsibility, and there's a requirement under 2.4 for a parent or guardian or some other adult to be present, but it doesn't actually give an indication as to how the child is required to accept this responsibility. And so we're suggesting that there's a consideration being given to including in the act what acceptance of responsibility means, or including in the act guiding principles and essential elements that capture the essence of acceptance of responsibility without being overly prescriptive. So this would promote a level of uniformity to how acceptance of responsibility is understood and applied across the various cases, and prevent varying interpretations of what constitutes acceptance.
All right, we may have to come back to that section when we get to Section 9, okay?
Yes, Minister.
Continue.
Still under Section 2.4, so the other presence that would be required would be, as I said before, a parent or guardian, an adult other than a constable, and then C, an attorney at law, or an attorney at law acting for on behalf of the child. The ministry also had another point under this section in terms of the reference to the child being age 14. So B would have said that an adult other than a constable who is present with the consent of the parent or guardian of the child, or if the child has attained the age of 14. So this assumes that once the child has attained the age of 14, the child is capable of giving consent. Under Section 2G, that's a connecting clause which we would have read before, the best interest of the child establishes that it is to be considered whether the child is of sufficient age and maturity so as to be capable of forming his or her own opinion. So we want to look at Section 2 carefully in terms of the reference to the child being age 14, and that assumption that is implied there that once the child is age 14, the child can give consent, and in the context of the best interest of the child, being that we're not only looking at age, we're also looking at, or supposed to be looking at, the maturity level of the child. So there are other suggestions there under that section if the committee is so minded to peruse in terms of recommendations for section 2.4, based on what I would have outlined before. We're now going to move on to section 3, still under part 1, and that deals with the objects and application of the act. So the objects of this act are to ensure that every child in conflict with the law is treated in a manner that recognizes and upholds human dignity and worth, diverts the child from engaging in deviant and delinquent behavior, and instills in the child respect for the fundamental rights and freedoms of others, taking into consideration the best interests of the child, the desirability of the child's rehabilitation, reintegration, and assumption of a constructive role in society, and the restorative justice proceedings under Section 5A of the Criminal Justice Reform Act. So the ministry did not take great issue with this section, save and except that we would have recommended for a better reading of the section, that it be revised to say that the objects of the act are, and then separate what is currently in the general framing of section 3.1 into 2 parts. So it would read, 1, ensure that every child in conflict with the law is treated in a manner that recognizes and upholds human dignity and worth. And then 2, divert the child from engaging in deviant and delinquent behavior, and instill in the child respect for fundamental rights and freedoms. So that was just a suggestion to say that we could split what is under 3.1 into 2 parts for further clarity.
That, as you can see, colleagues, members, is a very interesting recommendation from the Ministry of Justice team. So it's something that we should look at for consideration when we get back to it, okay? Mm-hmm. So, because once we have to declare the objects clearly. So, and as was pointed out, the language, you know, is a bit intertwined. So if we can be clearer when we get to it, we'll decide whether to adopt or to look at it. Samantha will also ask you to have a look at it. Samantha is the drafts person, okay? All right, continue, Sandy.
Yes, please. And also to look at generally, if the committee is so minded to just see whether or not in their estimation the objects of the act, based on what is in the act and what we want to achieve, sufficiently captures the intent.
Mm-hmm. Good.
Right. So we're on to part 2. So part 2 of the act, section 4, talks about child diversion. So under section 4, that deals with the establishment of the Child Diversion Office. It reads, section 4.1, there is established for the purposes of this act a department of government to be known as the Child Diversion Office, which shall be under direction of the permanent secretary in the ministry with responsibility for justice. Section 4.2 reads, the permanent secretary shall appoint to the Child Diversion Office in such numbers as may from time to time be necessary, public officers with qualifications, training and experience in matters relating to addressing the needs of children in conflict with the law, child diversion and child delinquency, one of whom shall be appointed as the head of the office. Now, I just want to make the point here that the ministry has some comments on that. At some point, I will hand over to Ms. Clark to just give the committee an overview of how the Child Diversion Office actually operates, which is a little different from what is stipulated in the Act when you look at Section 6 which establishes the child diversion committees, and then Section 8, which establishes the National Child Diversion Oversight Committee. So I'd want the committee to be mindful of these three bodies that we have under the Act. So we have the Child Diversion Office established under Section 4. We have the Child Diversion Committees established pursuant to Section 6. And then we have Section 8, the National Child Diversion Oversight Committee. So we should look at all of them together.
Venetia, Ms. Phillips, who is the Child Diversion Officer, we wait until we complete Section 8. So you deal with 5, 6, 7, 8. Okay, Venetia? So continue.
Noted, Minister.
Minister?
Sure, yes.
Just
Yes.
a quick question, and it can be deferred to that discussion on the three sections. Is it, just as we may have discussed it, and just as a reminder, is there a legal definition for child delinquency?
I don't
Is there
think
a
there's
definition of
any
that?
specific definition for child delinquency. I think we just use delinquency to the best of my knowledge.
Well, at least
but
not in this Act. Not in this Act. It could be in the Child Care and Protection Act, but we could always check. But not in this particular Act. It doesn't define child delinquency here.
Could we ask, when we get to that discussion, Senator Golden Campbell would could you check with the
I'd appreciate
Child Care and Protection Act for me, please, law reform? If there's any definition of child delinquency? No?
There is no definition for child delinquency in the Child Care and Protection Act.
And in no other act?
No,
Is there a common law definition?
I can't say off the bat that there is or is not
All right.
under the common law, but certainly in terms of legislation, I don't believe there is any act that
any of our
provides.
acts?
No.
I'm concerned about the use of a term like that. That sounds like a term of art
Yes.
that doesn't have a legal definition, because it obviously would have to be considered by a court at some point.
Sometimes you get into trouble when you start defining, giving
I'm not even
definition.
suggesting we define it. I'm wondering if it ought to be there at all. And I'm also thinking of the intersection between the Child Care and Protection Act, which has a completely different function than the Child Diversion
Well,
Act.
to be fair, this section speaks about delinquency rather than child delinquency.
It says child delinquency.
Where?
Minister. So if you look under Section 4.2, it reads that the permanent secretary shall appoint a child diversion office in such numbers as may from time to time be necessary, public officers with qualification,
yes.
training, and
I
experience
see.
to deal with children in conflict with the law, child diversion, and child delinquency. So it has those three elements.
I think Senator Goldenkamp makes a point. Maybe we shouldn't use the term. We will check on it. When we get back to that, Venetia, Ms. Phillips, let us know if that has given a concern, because as such, we may well have to remove the term child, just speak of delinquency. Okay?
Well, the concern for me, Minister, is the term delinquency, because I recall the Ministry of Education's interventions and the advocacy that they brought in terms of the functions of the Child Care and Protection Act.
That is correct.
And the Child Diversion Act. And I think at times we have been dangerously close to mixing two, yes.
Okay, a point to note, please. Okay.
Noted.
Chair, I don't know how to put up my hand.
Sure, yes.
But I wanted to point out that in relation to that section, it really is speaking to public officers with qualifications in these areas.
Oh.
So I think it says that the permanent secretary shall appoint to the Child Diversion Office. And it goes on to say these people with special qualification and training. So I don't know if it is that critical. If there is somebody who says, I'm trained in child delinquency, for example, I don't know if it's so critical for us to have a definition, as it is the permanent secretary who will be selecting the persons based on their qualifications.
All right, we can have further.
So just to revisit it in that context.
Sure. Thanks, Senator.
I'm persuaded by that, to Chair. Thank you for that, Senator.
Wonderful. All right, continue, Sandy.
Okay, so we're now on to Section 5 of the Act. So Section 4 establishes the Child Diversion Office, and Section 5 speaks to the functions of the Child Diversion Office. So the Child Diversion Office shall be responsible for the rehabilitation of children in conflict with the law and for the development, implementation, and administration of child diversion, and without prejudice to the generality of the foregoing, the office shall, in consultation with the National Child Diversion Oversight Committee and the Child Diversion Committee for each parish, A, advise the minister on matters of policy relating to children in conflict with the law and child diversion, B, monitor the operation of child diversion in the justice system, including the supervision of child diversion programs, C, review the methods, procedures, and processes used in child diversion and recommend any changes and amendments as appropriate. D, in respect of children referred to child diversion committees, develop, approve, administer, and supervise child diversion programs and other programs for the prevention of child delinquency and for the rehabilitation of children in conflict with the law based on the evaluations, knowledge, advice, and recommendations of the Child Diversion Committee of each parish. And we would see again that in D, there is reference to child delinquency here in terms of the responsibilities of the functions of the Child Diversion Office in developing programs that would essentially address child delinquency also. E, undertake research and statistical analyses to inform policy development in relation to children in conflict with the law and child diversion. F, facilitate, prepare, and conduct training programs from time to time for the judiciary, constables, correctional officers, public officers, and the public as necessary. G, monitor compliance with the provisions of the Act and the regulations. Mind you, we don't currently have regulations. H, perform such functions relating to children in conflict with the law as may be assigned to the office by the minister with responsibility for justice.
All right. As we indicated, Venetia is going to give us a discussion in these sections after.
Right,
Continue.
so once we go through, finish section 8, which would go through all the respective office and the committees, we can have a general discussion on how they interplay.
Right.
Right, so to section 5, the ministry had a comment in terms of 5D, should the office develop and approve programs? This raises questions as to the possibility of raising that there are unilateral decisions in that the office can approve, develop its own programs. So the committee may want to look at that to see if, in terms of the functions of the office and the functions of the committee, if we want to reword who is responsible for what. And there are overlapping functions with the committee and the office as well. Right. So we're on to section 6, which talks about the child diversion committees. So section 6.1 reads, subject to subsection 2, for the purposes of this act, there is established in respect of each parish of Jamaica a committee to be called the Child Diversion Committee for the relevant parish. Subsection 2 under 6 reads, in respect of the parishes of Kingston and St. Andrew, there shall be established a single Child Diversion Committee with jurisdiction for both parishes, which shall be called the Child Diversion Committee for the parishes of Kingston and St. Andrew. Section 6.3, every child diversion committee shall be a committee under the direction of the permanent secretary in the ministry with responsible for justice. And subsection 4 under 6 reads, the second schedule shall have effect in relation to the child diversion committee. So the ministry took no particular issue with this wording, save and except where I would have mentioned before, just examining section 6 in terms of the interplay with the committee and the office. Section 7 speaks to the functions of the child diversion committee. So subsection 1 reads, subject to subsections 2 and 3, the functions of a child diversion committee shall be to A, advise the child diversion office on all matters relating to child diversion in the parish, including individual child diversion programs. B, conduct any relevant evaluation, provide advice, and make recommendations to the child diversion office for the development, administration, and supervision of child diversion programs for each child referred to the child diversion committee. C, implement child diversion programs and supervise the participation of children in child diversion programs in the parish, including modified child diversion programs. D, coordinate child diversion related activities to ensure the effective administration of child diversion in the parish. E, provide advice and make recommendations to constables, correctional officers, and the parole board in relation to the treatment of child offenders and child diversion generally. And F, conduct research, studies, evaluations, and other studies, and collect data on matters related to child care and protection in the parish, including 1, the efficacy of child diversion programs in the parish, the performance and results achieved by child intervention programs and child-related activities undertaken by public bodies in the parish, the implementation and outcomes of policies and procedures related to child diversion in the parish. 4, identifying the causes and trends of child delinquency and criminal activity by and against children. 5, children detained or imprisoned in correctional institutions. And 6, the particular needs of children in conflict with the law or in custody or detained in the parish. And G reads, make recommendations to the minister and child diversion office for the development of policies and procedures for 1, child intervention programs, 2, the prevention of child delinquency, 3, the administration of justice in respect of children, and 4, the rehabilitation and treatment of children in conflict with the law. As you can see, there are a lot of functions. H, formulate and recommend policies and strategies for the prevention of child delinquency and for the treatment and rehabilitation of children in the parish who are in conflict with the law in consultation with the government agency with responsibility for children, and 2, the minister. I, nominate a member of the committee to attend the meetings of the Child Diversion Oversight Committee as required by the permanent secretary. J, furnish the Child Diversion Office with such reports, including an annual report, returns, accounts, and other information as the minister may require with respect to the Child Diversion Committee, and afford the minister facilities for verifying the information in such manner and at such times as the minister may reasonably require. K, furnish reports to the Child Diversion Office, the court, and constables as required under this act. And L, perform such other functions as the permanent secretary in the ministry with responsibility for justice may direct or as otherwise necessary to implement the provisions of the Act. It has a part 2, so we would have covered section 7.1 just now, so we're on to subsection 2 under 7. The Child Diversion Committee shall establish procedures to ensure that children are consulted and participate in the research, studies, and policy development undertaken by the Child Diversion Committee. Subsection 3. In developing the recommendations under subsection 1, the Child Diversion Committee may consult with A, the judiciary, B, the minister with responsibility for youth, C, the director of public prosecutions, D, the commission of police, E, the commission of corrections, F, the parole board. G, the head of the government agency with responsibility for children, H, the children's advocate, I, any other relevant government department, agencies, or other bodies, J, a non-governmental organization, youth and community organization, and finally K, any other person with the experience, resources, or expertise in matters relevant to this act. So we had a few recommendations. Minister.
Colleagues, we have gone through sections 5 to 7. Section 8 deals with the National Committee. I want to bring in Ms. Clark now, Sandy, and you can help her with some of the questions. Sure.
Before you move on, we had the discussion of, before it was brought up, if you notice, the word
Child delinquency.
Child delinquency.
Yes.
Comes up so often, so
right.
Probably that is what we need to do, put a definition or something.
Right, or just speak about delinquency.
Exactly.
Right.
I do think so before.
So I know that we'll have to make a decision, because if we don't give a definition to child delinquency, then it's there. Is it different from delinquency? And I think both Senator
Motley and Golding.
Are yes. The question is, we need whether we should remove the term child in front of delinquency. Just speak of delinquency.
And then if we speak of delinquency, Minister, in what context? Would we speak of it in the context of child diversion and children in conflict with the law, or because we wouldn't want to veer into what CEP, FSA might do in the same respect, even though Ms. Wright would have pointed out that it is not defined under that act, but how they treat with children who may be considered delinquent. Sure.
Member Buchanan.
Thank you, Chairman. I would just say that I think because of how many times it's appearing in the legislation at the definition section, and it's something we could work on, we would say for the purpose of this act, child delinquency generally, and I'm just throwing words out, and then it's something to consider. It refers to unlawful or antisocial behavior committed by individuals under the age of 18. And because we're saying child delinquency generally, it encompasses a wide range of actions from minor status offenses to serious crimes.
Where you got that definition?
That is just, it's AI. It's AI. So I'm not professing to be so au fait, but to say that it's something that we need to work on.
No,
but the aspect of it is for the purpose of this legislation, we said child delinquency generally, and then we can agree on how we want to craft it. And I know the drafters are present.
I think though we don't want to go on a tangent or out on a limb. I think we need to discuss this with the Child Care and Protection Act and get from the Ministry of Education if they have
a definition.
But apparently they don't. Right. But do they use the term child delinquency in that act? They do. I don't think so.
I didn't see it in that act, Chairman, but what I do say is because of its frequency and repetition, from the time the Senator raised it, it appeared 3 other times.
Right, and may appear more times.
And may appear more. And
Yes.
so it's a definition for the purpose of this act to say child delinquency generally, and then it's coined.
All right.
I leave it to
I
the
want to wrap,
drafters
I want to
to
wrap
say
it up and,
what it would be.
and
Very
make
well.
a decision when we come
Chair,
to the...
Chair.
Yes.
I want to say that we have to go a little further and look at what it is that the Child Diversion Act is intended to do. And in contemplating a definition, consider whether it's an appropriate matter to have under the legislation.
And this is
I'd
where...
like to see two approaches.
And I think Senator Scott Motley, this is where I was going, because all along you have heard me saying, I think we need to broaden the Child Diversion Act, its operation, beyond being in conflict with the law. Because at the moment it is restricted to being in conflict with the law. And I've always felt that delinquent behavior, you have heard me make this point before, delinquent behavior should be considered, especially where that delinquent behavior is referred to the child diversion officer by a guidance counselor, by a parent, you know, because a lot of these children, so-called out of control, which now are dealt with, they can't be dealt with until they're actually brought to court. And I'm just thinking that we may well have to look at the act to say, if a parent or a guidance counselor in a school or a community member see a child getting in a delinquent way, do they have to go to the police or to the court before it can be referred to a child diversion officer for them to get help? Or is it something that, you know, they could refer to the justice centers in the parishes who can refer to the child diversion officer? Because at the moment, Ms. Clark will tell you, unless it is referred by the police or by the court, they have no jurisdiction. And that is where I feel that the restriction on the child diversion office is such that we are not catering to those who are on the borderline, who we literally have to wait until they get into trouble before we can help them. Yes, yes, Member Hamilton. Go ahead. Sorry. I think Donovan was ahead of you. Go ahead first.
Yes, Minister. I just wanted to say that the delinquency, as you know, rightly pointed out, covers behaviors that may not escalate into a violation of the law.
That's the point.
No, the objects of this act is really restricted to a child being in conflict with the law. And I think some time ago we had some discussions here, and I think the Minister of Education, the Honorable Dana Dixon Morrison, was here as well, and she pointed out that there was efficient institutions or mechanisms in place, especially in the schools, that govern antisocial behavior. So the question is whether we have to be careful of overlapping functions.
That's the point.
Overlapping roles. So if we have to decide as a matter of policy whether we are sticking to conflict with the law and you know, a proper definition of the roles of the different institutions or entities that are in place to govern children behavior. And I think that's what we need to look at.
Sure. All right. Member Hamilton.
Chair, I wanted to support the comment that you made earlier. The reality is, in my constituency, parents come to me all the time having issues with their children. They don't know what to do with them. And it is for me to make a recommendation to them where to go. In a situation like this, I do believe broadening the scope would help in some situations. I don't think we should just wait until something happens for us to intervene. And I heard about the intervention where education is concerned, but that is for schools. You don't necessarily want that type of intervention all the time. You may want to take it to another place, for example. So I think it is something for us to consider because we are really having challenges out there with some of our children.
Sure. You see, if I might say to both members, Williams and Hamilton, there's a gray area. There's a gray area between, you know, in conflict with the law and delinquency. And certainly the question arises to what extent that gray area becomes darker. And, I just think, I accept that. But I don't think the present position, Member Williams, I don't think the present position, where you just wait until the child is in conflict with the law to refer to child diversion. So I've always felt that, I'm not denying that the Child Care and Protection Act is the one that should be dealing with these, should I say, deviant, delinquent children. But there comes a point when, the behavior is so outrageous that it's clear that the child needs help. And that is where the Child Diversion Office gets psychological support, get other mentorship and so on. And I'm not too sure that the Child Care and Protection Act, do they go that far, Venetia? Let us get some help from, because she has had to deal with a lot of these cases. Go ahead.
So, Chair and members, I just wanted to clarify, firstly, that the CPFSA, Child Protection and Family Services Agency, they do have their team with psychologists, social workers, and so on, who treat with children who exhibit behavioral issues. I think that is what Minister Morrison was alluding to when we were here. So while we treat with them when they come into conflict with the law, it is not that they're not seen before or they're roaming around and waiting to come into conflict with the law. So what I'm noticing is that there's need for more information to the public overall so they understand what we do and what they do. I know Minister mentioned when she was here last about their therapeutic centers that they're expecting and all of those things being rolled out. So I anticipate that that might help us in terms of getting a better feel of what happens to these children before they come into conflict with the law.
Chairman, if I may.
Go ahead.
If I fail to articulate myself the first time, just give me permission, because I hope I didn't make gray areas that don't exist. What happened with this discourse just now, it has only proven why the child delinquency has to actually be defined. Just to be clear, and I'm sitting beside my learned friend, who, the State Minister, Dalrymple, who we are consensus ad idem as I speak now. We agree. The definition in relation to child delinquency is to make it absolutely clear that it is participation in illegal behavior by minors, which typically individuals under 18. So it keeps the focus and restricts it that is children in conflict with the law.
Okay.
What we need to make clear that there are something that is known as status offenses. I think in Jamaica it's illegal to drink under 18. If we have children doing that, that is actually a behavioral problem and a status offense. They are committing an illegal act, and we have to deal with that. There has to be intervention. It's covered under this legislation. But that is conflict with the law. So the delinquency, we're defining it to say that, listen, it is in conflict with the law, and we're not getting any wider.
Okay, I see the point you're making. So what Member Buchanan is saying will capture what we're saying. No. You're saying you define child delinquency that will include behavior which, well, that's the point. You see, no, one second, go ahead.
That wouldn't require a definition because the child would already be in conflict with the law. So you wouldn't need to define delinquency in that situation.
I'll see why.
Go ahead.
Chairman, what we don't want is for someone to take up the legislation and make assumptions. That's why we're fixing it now, that delinquency means, so it's so broad. And it appears so much times in the legislation that they start to use the legislation to encompass children who are not covered under the Act. That is why you couldn't take it.
All right.
That's why it has to be different.
Well, Chair, it would require us removing it.
Well, that's the point. That's where the committee has to make that decision. You see, because what I think members are saying, the term child delinquency could be given a definition which allows right, but to the extent, Member Hamilton, that it could be sufficiently broad that that child doesn't have to be taken to court. No, we're not denying that. We're not denying that. To give you a good example, and I hope that people don't take me up on this. You take, for instance, consensual intercourse with between children. There's this debate which will come up soon, whether we should allow it to be decriminalized. It could well be child delinquency, even though we decriminalize it. But it could be that we call that child delinquency. So once it is there as a child delinquency, we can say, when we debate this bill which may come to Parliament soon, that the closing age is decriminalized, but it is child delinquency which allow mentorship under the Child Diversion Act. Because that is exactly what the pastor was saying. The pastor was saying, once you weren't here, you weren't here, Member Hamilton. Member Hamilton. No, but what we're, Member Hamilton, what we're saying, you see, no, you weren't here when a pastor was making the point that they didn't want consensual sex between close-in aged teenagers to be criminalized. But they want them to go to diversion. So this is a good example of where child delinquency could include that. Right. If I might say, and I can think of a few other examples where you're not going to charge them because it is more a breach of the moral law than an actual breach of the criminal law. Yes. So we need to look at that carefully. I think somebody wanted to get in.
Minister, if I may, just to remind the committee to just look back at the objects and applications of the Act that would have been read before, and that would add additional context to the child delinquency conversation that we're having. Under Section 3, the objects of the Act are to ensure that every child in conflict with the law is treated in a manner that recognizes and upholds human dignity and worth, diverts the child from engaging in deviant behavior and delinquent behavior, and instills in the child respect for fundamental rights and freedoms taking into consideration XYZ.
Okay.
So it captures it on, right, so it really captures it under the whole broader context of child in conflict with the law, based on what the object, right.
Right.
So we could look back at that.
Venetia. All right, so this definition of child diversion, we have not settled, but we'll come back to it, okay? But we want, Venetia, could you address some of the concerns on the section 5 to 7? Because before we get to section 8 that deals with the National Diversion Committee,
yes.
Could you say what challenges, if any, you have? For instance, have we been able to set up these parish diversion committees, and have they been working in a way that is satisfactory and in accordance with the definition in these sections?
All right, thank you again, Chair. So for the Child Diversion Office, it speaks to the setting up of the office that currently obtains, but I'm going to tell you what is happening now versus what the Act says. Most of the activity that the Act stipulates should be done by the committee is actually done by the Child Diversion Office. It's important to note, though, that the committee approves these activities. So it's not that the office itself is just working without the guidance of the committee. So once a referral is sent by the police or the court, it is received by the child diversion office. So the parish office receives that. Every parish has a child diversion committee with a number of members who are experts in different areas, including the Departments of Correctional Services, the child CPFSA, police, and so on. So once the...
But are they working?
Yes, the committees are active and they're working, and they span for 3 years. So once a committee is named, so the referral is sent to the office by the court or the police. Once the office receives that referral, they will do an intake assessment, and that is where we ask them a number of questions using our approved tools that we have to determine the risk level of this child and the underlying issues that we need to address, and find out what treatment we can propose for this child. So whatever matter comes before us, once the intake assessment highlights that they might be at risk for something else, the treatment plan that is created is presented to the committee with all those issues highlighted. So for example, if a child comes for, let's say, sexual intercourse with a person under 16, and we realize that that child is not doing well in school, or that child might need some social welfare support, we are addressing those matters as well. So the treatment plan that will be presented to the committee would include this sexual and reproductive health education and counseling, but it would also include maybe a referral to the Poor Relief Department or a referral to PATH, as well as other entities that the child will need.
Chairman, thank you. Two things. First of all, myself and Member Hamilton, probably you could guide us. Do we have one of those in Trelawney? Because we are not aware of them.
The Child Diversion Committee? Yes, they're in every parish.
And where in Trelawney would they be located?
So the Child Diversion Committee doesn't have an office because it is made up of a number of members. But when they meet, they usually meet at the Justice Center.
Well, that's the first point I want to bring to your attention, because it doesn't matter. It's like a horse that blinked and nobody saw it in the night, because we are not aware of it at all.
But you know, may I just say again, Member Dalrymple and Hamilton, it is one of the weaknesses of the Ministry of Justice, in that we have these committees that are working, but they're not well known.
Can I say something? I want to take up for the Ministry of Justice. It's not a weakness of the ministry. It is a weakness of the ministry not having a good PR team that is well paid to make people know, because it's excellent. But you know, the other point I want to make, and I really want to thank, it goes back to Member Shireen Golding, this whole thing of delinquency. She was the first person who mentioned it. And what is very, very important is that really the essence of this act is to help children who have problems without first pushing them before the courts. Because they say doctors differ, patients die. And sometimes when the children go before the courts, the very courts themselves, the children are traumatized.
Yes.
And even if you have the officer there, remember the court is supreme. So the poor officer is guided. Remember now, so-and-so, and the officer pulls back into their shelf and the child.
Remember now, colleagues, we're trying to get away from that. That is why the DPP's recommendation will be taken into consideration, that the DPP or the clerk of court can refer the matter to child diversion without bringing the child to court.
Yes, but most importantly is the point of delinquency.
No, but I think
that you don't have to go
No,
straight
but dealing
to the
with
court.
this particular matter, though, you see, the truth of the matter is that we are aware of the child diversion committees when they don't operate. Because I know in Hanover recently, well, that's the point. No, but I'm glad that you brought it up in Trelawney, that it is operating, but it is not known. And I can't understand Ms. Phillips, Venetia, because I know that the Child Diversion Committee in Hanover, they did get in touch recently to say that because of what took place with Melissa, a number of children were not being catered to because the Child Diversion Committee had not met to make an assessment.
Because the offices were closed.
In
Mr.
Hanover.
Chair.
So,
Yes.
Chairman, we are not saying that they are not functional in Trelawney. But I am saying we are both attorneys and we are not aware. So it means that they could be working, but you do need the PR team to help to make people know, because it's so important, and that is where your mind is, to stop crime at that level and to help children.
So Ms. Phillips, to the best of my knowledge, we have a child diversion committee in every parish.
So I think what is happening is that you probably need to know where the office is located, because a lot of people, they don't necessarily need to know about the committee unless they have a case or a matter that is being treated with. So the office itself, we have offices across the island, and the committees meet based on the invitation of the office. So if we have matters that are referred to us and we want approval for those treatment plans, they have to be approved by the committees.
That it doesn't matter if you have an office. Well, I'm speaking for rural Jamaica, where we both operate a lot. There's a lot of interconnection with the people you would have on your committees. And you can have meetings in public places where parents and people in the community can talk, even before you can't, before a matter comes before you. So that parents, they will tell other people, particularly in inner city areas, talk and say, we have this committee, it is there, but you can, because it's not very easy. Melissa makes it worse, but forget Melissa. Even before Melissa, parents are not aware, people are not aware. So it is happening. But as I say, it's like a horse that blinked and nobody saw.
Well, let me say this to the... What is happening is that this child diversion has just been in operation for the last 3-4 years. So a lot of teeth and pain. It is working beautifully when it works, when we get. But the truth of the matter, that's why I'm saying, from my experience over the last 3, 4, 5 years, I just feel that so much more can be done. You know, and that is where I am going, because when I... Right, and that is what we need to, and that is why, Ms. Clark, Venetia, the question is, these committees, do we need to do anything further with them in relation to the Act? Are these committees, as I'm trying to find out from you, operating in accordance with what the Act says? Does the Act need adjustment, or the committees need adjustment?
So there may be a need for a little bit more clarity in terms of the roles that are prescribed in the Act. So the Act, some of what is stipulated is done by the office itself and not necessarily the committee. But as mentioned before, nothing leaves the office without the approval of the committee. So if a treatment plan needs to be modified for a child who may not be interested in re-enrolling in general school, but hard trust NSTA or they started working, so the modification would have to come from the committee. If a matter is being returned, the committee has to sign off on that as well. So those roles, outside of that, the evaluation that is done, the administering of the program and the supervision itself takes place with the office. So the officers are the ones who monitor the programs, they're the ones who follow up with the service providers, and the ones who update the committee and the court and police about what is happening.
All right, so what I'm going to ask you, Venetia, Ms. Clark, is to work with the drafts, with Sandy and Julia and the draftsperson, to see if there's anything to be done with these sections. You understand? Yes, Sandy?
Yes, Minister. What I'd want the committee to perhaps look at on the same conversation is the fact that the Act says that when you're talking about referring the child to child diversion, the child is referred to the child diversion committee. That's what the Act says generally. But what Ms. Clark is trying to explain that technically it comes to the office, who then reviews the matters and then makes a presentation to the committee. So technically, it's not referred to the committee in the first instance. It's actually referred to. So if we're right, so that is what we need to decide. As well, the committee needs to look at in the Act, taking into consideration the points that Ms. Clark would have made in terms of how it works operationally, which is not exactly how it is stipulated in the Act.
Sorry.
I was just saying, through you, Mr. Chair, is that as Venetia pointed out.
Venetia Clark.
Pointed out earlier. Sorry, Venetia. I was trying to find the
Clark.
My apologies. As she pointed out earlier, the committee itself doesn't have a physical location. It's comprised of
really
individuals.
At the justice centers.
So you would find that obviously, naturally, you would find that the report would naturally be made to the office. Correct? And the question I would ask is, has that process been working in terms of it being that someone comes to the office or the matter is referred to the office and then it is filtered down to the committee? If that is working, then I don't think we need to fix.
It's actually working.
We don't need to,
Sorry, all right.
Right, the only thing we need to fix is how it is worded in the legislation. If we want the legislation to say the referrals come to the office,
and then,
as opposed to the
and that's
referrals
the point,
coming to the
I'll
committee.
take your point.
So what we agree on, it should say refer to the child diversion office. You see, because the committee is a loose set of persons. Sorry, go ahead.
I just want to clarify for all the members. So we have 14 parish offices. So the one in Trelawney is at the Rock, close to the family court and the victim services
Close to the
office.
family court at the Rock.
Yes. But we do have offices across the island.
Yes.
So while the head office is at the Ministry of Justice and Constitutional Affairs, the offices are across the island. So they can,
Every
matters
parish
can be
has a
referred.
justice center where there's a child diversion officer and a restorative justice officer. Victim services are some, but there are some parishes where the victim service is separate from the. We want all the social justice services to be at justice centers when we finally roll out. Okay, now the next section you see, Section 8, which deals with the National Committee. To the best of my knowledge, we don't really have a functioning National Committee, right?
Not at the moment, Mr.
So the question arises, colleagues, we're going to ask Ms. Sandy Coljar to read Section 8, and the question is whether or not we really need this National Committee. Okay, so go ahead.
Okay, so Section 8 reads, so it's the National Child Diversion Oversight Committee. That is what it is called. So the minister shall establish...
Me?
Yes, minister.
Not shall.
Shall, yes, you're mandated, minister, to establish this committee.
Sorry?
Yes, minister, you shall. The minister shall.
No, man, it says me.
The minister shall.
In the act itself, but
yes,
in your...
it says. So that would have been an error. My apologies. If it says may in the document that you have before you, that would be an error. So it actually is, it's may. Shall, sorry, it's shall. Right, so we're clear. So the minister shall establish a national committee for the purposes of this act to be called the National Child Diversion Oversight Committee, which shall be under the general direction of the minister to A, monitor and report to the minister on the implementation of child diversion in Jamaica, B, review compliance with the provisions of this act, and C, advise and make recommendations to the minister on child diversion and the treatment generally of children in conflict with the law. Under 8.2, the National Child Diversion Oversight Committee shall consist of such numbers of persons not being less than 7 nor more than 9 as follows. The permanent secretary in the ministry with responsibility for justice, who shall be the ex officio member and the chairperson of the National Child Diversion Oversight Committee, or a public officer in the ministry with responsibility for justice, nominated by the permanent secretary with responsibility for justice. B, the children's advocate. C, the head of the government agency with responsibility for children. D, if required by the permanent secretary with responsibility for justice, such members of a child diversion committee nominated by that child diversion committee. And E, such other persons suitably qualified in accordance with paragraph 1 of the second schedule, appointed in writing by the minister for such period not exceeding 3 years as the minister may specify. Under 8.3, in the absence of the permanent secretary with responsibility for justice, the nominee of the permanent secretary referred to in subsections 2A shall act as the chairperson of the National Child Diversion Oversight Committee. Subsection 4, the members of the National Child Diversion Oversight Committee appointed under subsection 2E shall be eligible for reappointment. Subsection 5, the minister may at any time revoke the appointment of any member of the National Child Diversion Oversight Committee appointed pursuant to subsection 2E if the minister thinks it's expedient to do so. Subsection 6, a member of the National Child Diversion Oversight Committee appointed by the minister under subsection 2E may at any time resign his office by instrument in writing addressed to the minister and transmitted through the chairperson, and from the date of receipt by the minister of the instrument, the member shall cease to be a member of the committee. Subsection 7, so 8.7, the National Child Diversion Oversight Committee, A, may make decisions on the basis of a majority vote, and if the voting is equal, the chairperson shall have a casting vote, and B, subject to the provisions of this act, may regulate its own proceedings.
Good. Now, the truth of the matter is that the minister, unfortunately, did not set up this national, because I think the office was more concerned to get the matters rolling in the parish with the committees. But we must decide here whether we really need this National Oversight Committee of the Child Diversion, because it is working fairly well in the parishes with the parish committees.
Yeah, but if it, through you, Mr. Chair, if it pleases you, but I think this oversight committee could assume significant, even more importance now, in the sense that we are now contemplating reviews. We're reviewing the act, and it would be good to see after the review and the implementation and the amendments and a new act. It would be good to have that oversight body in place to see how things are working.
I think we should change it to me, from Shall to me. so I don't know why I thought it was always me. No, all right, so that's something we will discuss further, okay? All right, sure, go ahead.
Sure. Instead of setting up a national oversight, the minister could delegate.
Well, the point about it is that the committees in the parishes are the real operational committees.
Yes.
The oversight committee was, as the actor said, is to look at how
it's working.
It's working.
And it's working. Yes,
and
it's working.
The parish committees are the ones that are doing the work.
Yes, I think so. I think
exactly.
So. And I think that if there are resources available, instead of spreading it, it should really be concentrated to the parish committees that need the resources.
And that's the point, you see, because
or
the oversight committee, sometimes you put them in and they really just interrupt matters. Sorry?
I think it's a matter of reporting, because based on what I've seen, the committees report to the permanent secretary. And then the oversight body would report to the minister.
Right.
But they both have similar functions.
But that's the point, to see, because once the committees report back to the ministry from
I
the
think
parishes,
that should be sufficient.
you get everything.
That's the point I'm making.
You get everything. So to ask to set up a committee to go and just check and collect report, I'm not too sure that Section 8, what is important is to strengthen the parish committees. You see, and so this section may not be really be necessary. I think we could just change it to may and leave it there. But the parish committees need to be strengthened so that at least the various stakeholders in the parish are aware of who are the members of the committees and whether or not they're functioning well. Okay? Fine. Now, Section 9, we need to spend a little time on. So we're going to start with Section 9, and we're going to look back at Section 2 to see how it corresponds with 9. So, colleagues, just have a look at Section 9, please. Go ahead.
If you would permit me, Minister, just to make a point on what you just wrapped up in terms of the reports, if you look under the functions of the Child Diversion Committee, there's a section that says, if you look at Section 7.1J, there's also a reporting function to the minister.
That's right.
Via the committee. So you can look at it in that context to see if you really need
a national
national committee,
Exactly.
if the reports would have been furnished to the minister via that committee. So the committee the Joint Select Committee can look at that to see whether.
I think you're right. Yes, I mean, because once the parish committees are working and they're reporting to the minister, I don't see the need for the national. Yes. Okay. Yes, go ahead.
Mr. Chair, I know we'll get there toward the end of the going through the document, but we have a minor challenge with the committees. So you know we have members from the Jamaica Constabulary Force, from Child Protection and Family Services Agency, Department of Correctional Services, the Ministry of Education, and so on. The challenge that we find happening is, say for example, we have someone appointed to the committee as a guidance counselor, but for whatever reason they are no longer in that role. The time that it takes for these entities to return a new nominee, sometimes it is very long. And if we don't have a quorum for the meetings, let's say a police is reassigned to another parish, it affects our ability to respond to the matters quicker.
How many members you generally have? I think we have about 5 members in the parish committee.
So 5 members would be the quorum, but you have a maximum of 11 for each committee.
So what's the normal numbers we have in each of the parishes now, the average?
Repeat the question, Chair.
The average numbers we have in each of the parish.
Committee members?
Uh-huh.
I want to say about 10 on average, because some committees will have their full complement, while some are about 8. Because again, the response time for some of these entities, it takes a while. And if there's a way for us to say, okay, they can nominate another member without having to go through the lengthy wait time, while we will do our vetting and so on, we don't want it to be so long that some parishes we've not had officers. Let's say, for example, a police officer, because the one nominated is in 2 parishes away and they're not able to do it. And sometimes we need that additional person to make the quorum.
All right. All right. Well, remember now you're going to give us some indication of what changes you'd want to the legislation to ensure that the parish committees work better. Okay? We might reduce the quorum to 3, something like that, or you increase the numbers to 15, as the case may be. No. I want to welcome, by the way, I didn't welcome to the meeting members Williams and Buchanan, but everybody saw you coming. But I have to welcome Minister Dana Dixon, because for the past hour we have been discussing matters which really were in your portfolio.
Chair, that my colleagues were defending my little jurisdiction.
No, there's no doubt about that.
Thank you.
Right. So one of the things, Minister Dixon, we might do is that the next sitting asks that you, the representative from the Child Care and Protection Act, be here with you. I think we're having a little challenge speaking for myself, and I think I speak for a number of committee members, we would want the Child Diversion Act to be a bit more preventative rather than to wait until the child has come into conflict with the law. So we're looking at that gray area where they are deviant and the Child Care and Protection Act, which comes under you, take care of them. But there comes a point when it is obvious that they're going to end up in the court or in some criminal behavior. Is that any possibility, and we're looking at the definition of child delinquency, that we can capture those persons before they actually commit, being in conflict with the law. So there's that sort of firewall, not firewall, but a gray area between the Child Protection Act and the Child Diversion Act, where we can see how we could either work together or in that gray area, it could go either way, as the case may be.
Thank you, Chair. I really believe that child diversion and the act as it was established was really about children who came into conflict with the law. I think changing that is a fundamental change to the underlying principles of the legislation. I'm not sure that was what our intent was. And as I've said previously, the Child Care and Protection Act, there are changes to it that are to come forward. And we're going to be doing a joint select committee on that, as well as on the Adoption Act and so on. So I'm not necessarily there yet with you, Chair.
Sure.
Because I think the Child Diversion Act is about child diversion, children in conflict with the law. That was the premise upon which it was promulgated. And so I think in terms of a review, we should be sticking to that. Now, do the two work together? And they have to work very well together because there are going to be instances where there are gray areas. And so I think administratively, I think the teams already do work quite well together. And so administratively, I think that's where we have to just make sure that no child falls between the cracks.
No, if I might say this, though, Minister Dixon, the truth of the matter is that there are a number of behavior which really should be yours. And I say child care, when I say yours, your ministry, Child Care and Protection Act. But because of the behavior of the children, they have not yet committed any offense, These so-called out of control, you know that term, out of control. And the families and the police take them to court for the court to refer them to child diversion. You see, no, and as Ms. Clark will tell you, they have to meet them in the correctional centers, isn't that right? That's where they start to treat them when they're in the correctional centers. So the issue really is, as Member Hamilton referred, if a parent has brought up a child who is really delinquent, they don't want the police to arrest them or to take them to court. But is there that opportunity, because of the behavior, they're doing things which borders on illegality, for the parent or a guidance counselor or someone to just refer them to the child diversion office without waiting until the police say take them to court. Because what we're trying to do is to keep these children away from court. Now, to be frank, the truth of the matter is that the child diversion officer may well say, let's work with the Child Care and Protection and you take over because this is in your portfolio, or you're overburdened, we will take them. Because what has happened with child diversion is that we have had to be doubling up on our officers, and we don't mind tripling up if necessary, because in doing so, we find that we're being successful in really taking care of a number of children. And the reason why, not that I want work for the ministry, but the reason why I don't mind the work for the ministry, the truth of the matter is, it is working. What I mean by this is that we're getting an 80-odd%, 90%, success rate. Isn't that so, Mr. Lever? Huh? compliance rate. So once the child diversion officer have them in control and they get the mentorship and whatever the process is, we're finding that the compliance is not bad.
Yeah,
it's good.
And I think it's just a matter of principle.
Sure.
For me, I want every child to get the support that they need.
Right.
And for me, I'm agnostic in terms of where they get it. But there is a principle of, do they get it in a justice-related fashion, or are they getting in more of a social work manner, right? So I don't have an opposition to in this piece of legislation putting in that the child diversion unit can develop additional programs that are aimed at preventing children from coming before the law. That's fine. And I think that anyone would want to be able to do programs like that in collaboration with CPFSA. So I have no problems with that kind of languaging going in.
And this is where I say that before we finish.
Yeah, and I'll talk with CPFSA on that.
We need to find a way
Yeah.
how we can work in that gray area together.
Right, and I think it's important that we work in that gray area because there are a lot of children that need support. And so the question I have is how you legislate it in an act that's supposed to be about children that have fallen into conflict with the law, because there are actually other pieces of legislation too. So if we look at what's happening in the Ministry of National Security and Peace, the Ministry of National Security and Peace has some new initiatives where they're coming into the schools and they're identifying the children, like what you're saying, who may be on their way to being in conflict with the law. And they're instituting programs with social workers and with the ministry's guidance counselors and so on. Now, that's not legislated anywhere.
Sure.
So we don't need it legislated. We need to develop the programs that are supporting our children. And like what you're doing now with conflict resolution, the Ministry of Justice is doing fantastic work in the schools, assisting us in terms of teaching conflict resolution to our children.
Right.
That's not legislated.
I see the point.
All right, thank you.
Thanks, Minister Dick. All right, we're going to Section 9. Let's see if we can finish Section 9 before we are thrown out of ballot here.
Okay, we're on, as Minister said, we're on to Section 9 of the Act. And in the overview document that you have, that would be on page 33. So Section 9.1 of the Act reads, unless the public interest otherwise requires, a child who is suspected to have committed, is charged with the commission of, or who has been convicted of a diversion offense may be referred in accordance with the provisions of this Act to the appropriate child diversion committee for participation in a child diversion program by A, the court, or B, in the case of a diversion offense specified in the first schedule, a constable having reason to suspect that a child has committed the diversion offense. Subsection 9.2, a child referred to in subsection 1 may be considered for referral to a child diversion committee for participation in a child diversion program, A, if the child accepts responsibility for the diversion offense without having been unduly influenced by another person to accept responsibility, B, if there is a prima facie case against the child, C, with the consent of the victim of the offense if identified and located, and D, with the consent of the child, which shall be given in the presence of 1, the parent or guardian of that child, 2, an adult other than a constable who is present with the consent of the parent or guardian of the child, or if the child has attained the age of 14 years, the consent of the child, or an attorney at law acting for or on behalf of the child. Subsection 3, where a child is charged with a diversion offense, the prosecutor may, if satisfied of the matters mentioned in subsection 2, recommend to the court that the child be referred to a child diversion program. That's section 9.
Right. This, colleagues, everyone, is a section that has given a great deal of concern. As you recall, I did mention that the courts took the view that accept responsibility meant that they should plead guilty, which is the last thing I said is desirable. In fact, when you look at Section 32, it gives the clear indication that the child should really not be charged, or should be charged but should not be convicted. And pleading guilty is a conviction, but having had many discussions with the judiciary, their interpretation was from they accept responsibility, they plead guilty, and then they go on child diversion, which is, to my mind, was not the intention of the legislation. So we have to make the intention of the legislation much clearer. In other words, accepting responsibility means that they are in a position to move to the child diversion program rather and away from the court. As you will recall, the position of the DPP would be that they should be able to refer. So in that particular subsection 1, the referral really should not only be from the court or from the constable, but it should be also from the DPP or the clerk of court. You recall that we had said we would agree. So Samantha, just bear this in mind. In terms of the referral to a child diversion, to be frank with you, once the child has committed or suspected to have committed an offense, then we don't, which is where we were, Minister Dixon. Once a child is suspected to have committed an offense, where the constable literally charge the child. So they go to court, or the constable frequently, before charging, can actually refer the child to the child diversion office. We want to make it clear we don't want the child to go to court. Only in the most exceptional case. So once we know the child diversion offenses, then we want to be able to, for that child, to get the mentorship, to get the assistance without the trauma of being pulled up to court. Because once they get to court, it's more traumatic than anything else. So I see it in the OPC. We need to find a way. We will keep the court there, because there are some offenses, which you will later see, which are not necessarily child diversion offense, but the court has a discretion. You understand? The court then has a discretion to say, because they were found with a bullet or a toy gun, as the case may be, that although this is not in child diversion, it's clear that this child has been playing with toy guns or, playing cops and robbers, which they need to stop. And in those circumstances, you really need the mentorship for a while so that, that child can be diverted away from that sort of behavior. But to the best of my understanding, and this is where we must agree as a committee, we want to keep the child away from the court. So, and that is why the DPP was very firm to say that leave it to the clerk of court and the DPP to say that they refer the matter directly to child diversion without taking the child to court. So, yes, Member Buchanan.
Thank you, Chairman. This is the very section that I think we had lengthy discussions about originally when the Act was
promulgated, yes.
Promulgated. But there was an issue that it had a period where children were already convicted. And so I'm seeing language where it says, or who has been convicted. And if we're at that stage now where that verbiage would be removed, and then the second question would be at Part A where it says the court, if that's where we're putting or the DPP. Well, I'm just wondering because I remember when she gave her
we have to,
or a C. If it's
we have to make a decision.
Okay, but I'm just highlighting it there because there are two things that you said why I raised that question now, because the DPP, when she gave her submissions, said she didn't mind if you know, if it was referred to her and they gave, you know, they would do the referral. And so I'm seeing where B speaks about first schedule offenses, and if we're going to have the conversation as to what offenses you're giving the DPP the power to make referrals to as she reviewed the files.
No, well, we are going to add the DPP. Or the Crown.
The Crown, that is so.
Or the prosecutor.
Prosecutor.
In that section, this is why the OPC will put that in.
Thank you, Mr.
The other question is, it's useful to see, so that the child knows that they have to comply. It's useful that they have a person or in position of authority to say, if you don't comply, then you're going to go further. You might get into the court. So at one time, I thought we could say a parent or a guidance counselor, but it may well be that we have to find a way to route it through the police officer, because the child could be brought to the police station by the parent, and the police officer who listens to the complaint of the parent, or say in the school, as that youngster was pointing out, if you have a disciplinary committee in the school and they have a constable there, the constable can then listen to the complaint of the behavior of the child and then say, I'm going to refer you to child diversion, and point out this is the behavior that needs correcting. And so the child diversion office would then know what is to be done in terms of mentorship and guidance to get them out of that particular type of behavior. But you need an authority to say to the child, if you don't comply and participate in the program of the child diversion, then you could well be charged.
Chairman,
Yes.
I agree with you a zillion %. I'm just going to make the plea now that there's some language still about consent that I don't know how we're going to treat with it here. But I would only submit that based on what you said and what the object and purpose that we're trying to achieve, that the diversion has to be mandatory. This is one time I will say that it would be demonstrably justifiable in a free and democratic society for it to work, that whether it be the court or the DPP or even the officer in his wisdom, it's a wisdom judgment. If an officer decides that this is a child that needs diversion, can be saved, it has to be a mandatory call. And I'm saying this in the context that, if you would permit me, courts give adults bail and say report Monday, Wednesday, and Saturday. And somehow that communication between lawyer, prosecutor, and judge is as if the person doesn't hear, doesn't understand. I cannot, in my mind, figure how, if that adult is a parent, would be able to make a decision that a child is to participate in a program. And so I'm respectfully saying the aspect of child diversion has to be mandatory so that the psychologists and the persons who are making the assessment can give the child the opportunity to be outside of an environment where they can reset, relearn that this is actually a benefit.
Yeah, but to be fair, as you know, Member Buchanan,
yes,
there's no one conduct. There's a multiplicity of conduct that has to be dealt with. You take the situation where a child, say, wound or assault another child. The other child may well want the matter to go to court, as you appreciate. But what we do in the Ministry of Justice is try to get restorative justice to deal with both sides, to urge the victim, that you can come together. So to the extent when the children who are referred to a child diversion, oftentimes it's because they have hurt someone else. So we use restorative justice to bring them together. So what I'm really saying to you is that there's no one particular process that fit. In other words, that is where the strength of the child diversion officers who are trained in social work, that look at a variety of programs that, to assist. Having listened to a number of testimonials from persons who have gone on the child diversion, I'm just amazed. I think I've told you this case of this youngster at William Nib, right? Who was just misbehaving. And what the child diversion officer did, it doesn't matter. I mean, he's no outstanding youngster. What the child diversion officer directed him to go train to become an athlete. So every evening he was out there training. And I met him because he needed funds to go to the pen release.
So he excelled. But Chairman,
no, I mean, this is just amazing.
But Chairman, that's exactly, I'm not cutting you, but that's exactly the point I'm making, that I hear what you're saying, but the child diversion aspect of it is where the program comes in and the intervention. I think how we communicate in terms of, because there will be victims who are hurt, and this is public education. Sometimes persons just want to be recognized and they want to hear sorry. And they're not aware that that can be done in restorative justice. Right. And I don't see any conflict between restorative justice and mandatory.
It's complementary.
No, I know. I'm saying and mandatory the child diversion process, because a victim will say, but that's not fair. But the child still needs the diversion program to curtail conduct that doesn't become modus operandi or doesn't start to form a part of the character.
Thinking about it though, Member Buchanan, to be fair, you say mandatory, but unless the child is willing and consent to the child diversion program, you may not get the best result.
You understand? Because you can't.
I hear you. Chairman, it's a wisdom call, and I want to say the willingness is not in this situation is not consent, because minors generally legally can't consent, and I just want to make it clear that they'll say no because they don't know what it is. It's a culture or a habit that has to be broken, and I think for the purpose of the introduction of the diversion, they simply needs to be, it has to be a judgment call from the officer, the DPP, and certainly the court.
No, actually, I'm not going to deny that.
Okay. But I just can't think of a situation where a child says, oh, I don't want to do that. Sentence
the main thing I'm saying...
Give me a sentence.
But Member Buchanan, the main thing we are saying is,
yes,
you don't want to send a child to child diversion knowing that it won't succeed. What I mean by this, the child may well just force to go child diversion and just give the child diversion officer nothing but trouble. In other words, and the child diversion officer will just keep going back to the...
Senator, the Senator Shireen Golding, member, Campbell, went through length in explaining. I think she had said it doesn't matter the cost, but there are a lot of them need psychological assessment. And it was in this, if my memory serves me correct, it was in this forum, as in on this topic. So the child that is giving trouble, I mentioned in the Fair Prospect High School, because the Minister of Education is in the room, where there are students says, well, they send me to the school, they say I don't have a future, them say me don't, them say me no good, so me just do that. And once they're taken out of a particular environment and they're engaged, I can imagine being given a mentor that says you're worth something, and they say, for real? And they say, yeah, what you like? And they say, well, I like to build a computer. And I say, let's give it a go. And the life change. And you'll be getting, all members will be getting letters. Please provide ticket money and this because of the robotics program. And then we say, Lord, we need a CDF increase, because the children no longer have a certain habit, but have ambition. And I think that's what the spirit of the legislation is about,
Absolutely.
and why I'm saying that it needs to be mandatory initially, and there needs to be some kind of assessment so we know that I don't want to participate. It's not a cry for help.
I'm not disagreeing with you.
No, I know, but
You
I'm
know,
making my pitch now so it's not lost in translation. I'm passionate about this aspect. Thank you.
Okay. Yeah.
Okay, I'm sorry, Sandy.
Right. So there are a couple of things I want to clarify based on what has been said here so far in this discussion under Section 9. The ministry actually has a number of issues that they would have outlined in terms of what we've identified under Section 9. But Member Buchanan, to your question about the DPP, the discussion had surrounded Section 9.3. If you look under Section 9, it would have referenced the court and the constable being able to refer the child to child diversion. It also mentions the prosecutor. So it says that where a child is charged with a diversion offense, a prosecutor may, if satisfied of the matters mentioned in subsection 2, recommend to the court. So the discussion was that we don't necessarily, or the recommendation was that we want the prosecutor to be able to independently refer the child and not have the prosecutor recommend to the court.
No, I think we're agreed on that.
Right, so in that context, we had also discussed the Antiguan model for the committee to look at, because they actually have what is called a child justice board. So what that board has is a social worker, a magistrate, and a clergy. So they assess the child once the child comes in conflict with the law, assess the child in that board to see whether or not the child can go to diversion. If not, the child goes to diversion, the child fails, then they determine whether or not the child pleads. So we don't necessarily have that system, because what we have is the constable who would, at the caution level, if the offense is at the caution level, say that they can or they may refer the child to child diversion, or if the child comes directly to the court, then the court can refer the child to diversion.
Senator Shireen Golden Campbell, you wanted to come in?
Yes, Chair.
Yes, sorry to keep you waiting. Go ahead.
No, that's fine. Thank you. I was listening to my colleague, and I wanted to ask a question. When we talk about referring a child to the diversion program, is the fact of the referral a punishment, or is it a rehabilitative effort?
Well, bear in mind that punishment includes rehabilitation, right? No, but I think to answer you directly, the idea is rehabilitation. There's no doubt in my mind that, because we see if the child does not go through the program satisfactorily, then the child could actually be convicted or could go through the process where they're punished. So the child diversion program, I would say, is to ensure that the child gets the opportunity to rehabilitate before making a decision whether they should be brought before the court or to be found guilty, as the case may be. I don't know if that answers you.
And so it does answer my question, because what I am hearing from you is that the policy imperative is that the child diversion program be a rehabilitative mechanism for a child before a sentence. And if that is the case, then I would want to support the suggestion that it really, for the specified offenses, ought to be mandatory that the child is referred to the program as opposed to discretionary. And I would be supportive of an approach that in specific circumstances or in appropriate circumstances, perhaps in the most egregious situations, that a court could make another determination. But it would seem to me, this whole scheme of accepting responsibility and the criteria for being able to be referred, if we're talking about children and we're talking about a policy position that we want to be able to give them another chance because, in fact, they are children, then I'm not sure why we're dancing around this mandatory versus discretionary discussion. It just seems to me that it should be a mandatory position.
Minister.
Thank you, Chair. I believe that a lot of our children who end up in conflict with the law are acting out from things that have happened in their home and in their communities. And in many instances, there is a whole lot of trauma that they've been through, and they need support. I believe that from a policy position, if we really care about our children and care about what they have been through, we need to see them as all potentially productive citizens of this country. And so I very much believe that any child who comes in conflict with the law, obviously not in terms of murder and the other areas that we have excluded from this legislation, that they should be given that opportunity. Every child should be. And I understand the example of having that board that looks at, whether you should or you shouldn't. I think we could, in Jamaica, say to all our children, you matter. And so everyone, we believe you deserve a second chance. If it doesn't work, then we go through the legal process, but every child should be given that opportunity.
Good. Well, let me just state my position. I agree, that the child should go to child diversion once they have committed a child diversion offense. The concern I have is, can you force the child? Your answer is yes? Yeah. Yeah.
Minister, the whole aspect of the child diversion program is, as you hear about child diversion, the first thing that comes to mind is that it's not something for the courts. And therefore, if it is not for the courts and you're trying to guide the child, you have to guide the child like as a parent and say, this has to be done. So you have to force them to do it.
You see, the way that the legislation is at the moment, the child is referred with the child's consent. And
no, the child is a child.
Once the child is 14
Remember,
years,
we are saying the child is a child, and you're trying to help the child. Because the child is a child, the child needs firm guidance if you have to help them.
No,
and the guidance is you must go to the program.
And bear in mind, I come to you, Ms. Clark, after I make this point. The point about it is, for it to succeed, as I said earlier today, you need an authority figure to refer that child to child diversion, because with the authority figure or with some authority, they're more likely to comply. You see, if the child is referred by a constable or by the court. But what do you think, Ms. Clark?
Minister, I just wanted to present some things for consideration. So when it comes on to consent, we've had lived experience where we have children who don't care to be in the program. So from my understanding, when we spoke about acceptance of responsibility, that component was for the child to say, I am willing to be a part of the program. Yes? So, no man, I'm just clarifying what happens now. If the child doesn't want to be in the program, that child will be non-compliant and they don't care about court, they don't care about the police, they just do not want to be in the program. So that is one component, and while we can discuss that, and I don't have an objection to us discussing that because we're here for that, I also want us to consider another component. So in order for justice to be balanced, there's a victim and there's an offender. We have to, unless it is a victimless offense, we have to remember that victims have a right as well. And if we don't consider their views in the decisions that we make, the issue that we're trying to correct, we might end up having another issue in terms of reprisal. Because if I'm injured by someone and let's say someone is injured and they're taken to court, and it is stated that it is mandatory for this child to go to child diversion, and that is the only thing that will happen, we will hear nothing else. that defeats the purpose of restorative justice and victim services in terms of considering the balance that is required for justice. So while we make the decisions, I don't want us to forget that the victims look forward to not only healing psychologically, but feeling as though they got redress.
Minister.
I want to differ, and I can give you practical experiences. Listen, although you think that the children, remember we're dealing with children, they will say, me not go in there, me not this and that. They need help. Just before, and I'm saying this openly, just before our last election, in court was a matter with a child who was from a representative of one side who had damaged a child from the representative of the other party. I mean, grandchildren of both representatives. And they came before the court. And it wasn't child diversion. The judge, in her wisdom, asked him, the mediation officer, if we could go in. I happened to be the attorney on one side, and there was an attorney for the other side, and we went in. And they both went in, and by just talking to them, within an hour, both children were put back before the court, and the matter was removed totally from the court. I am saying to you, that is why you have to choose the officers that you use well, because a child is going to come and say, me now go in there, because background and a lot of things are involved. But if you can spend the time, and I do believe, I go back to what Member Golding has said with the whole idea of delinquency. If the aspect, and that's what the minister has been pushing, I think what the minister wants out of this is the fact that with children, we still treat them as children. So a lot of them have problems because of various reasons, background, psychological, all sorts of things. And as we hear child diversion, our first approach at all costs has to be that you don't push them in front of a court. And Minister, where I part company with you is that they have to be forced at some times. Because as parents, yes, our parents have forced us in some circumstances, and we turn out all right, because at a certain age and stage, we don't see the wisdom of it, and that is where I am with it.
Member Buchanan, you wanted to come in.
I'm just responding to Ms. Clark. The idea is that the act is saying we are taking one, at least one, I'd say 2, 3, 4, an opportunity to divert them, an opportunity to save them from facing the court. That's the aspect that is mandatory, but also to say that hurt people hurt people. Victims who are hurt, they want retribution. It is not until they are given the medium, the intervention, whether it be mediation, whether it be restorative justice, that they realize that they are given some power. And it may be an adult, it may be a child, and in those arenas, they say, well, like how me hear him say, sorry, don't bother send him go jail. But they were able to be heard. And there are issues of compensation and public education that we are going to be forced collectively to ensure that people understand what their rights are when these mechanisms are being used. And all I'm saying, when it comes to child diversion, Member Golden Campbell asks a serious question. When it comes to diversion, what it is that the child diversion is. And we must say to the public, when you hear child diversion, it's benefit. It's not punishment. It is we are doing that. And the last thing, Chairman, because there's some sidebar conversation as to whether persons were forced or volunteered. As I sit before you, Chairman, my mother forced me for education. Otherwise, I would be nothing. And that's important for people to accept that. If it were not for corporal punishment right now, I go, stop me, Chairman. turn my mic off lest I get myself in problems.
Further trouble. No, I think, colleagues, this is where there's a conflict with Section 2.
Right.
You see, because both Clause 2 and Clause 9 make it a choice.
Right, and the definitions as well, Minister, because if you look at the definition of child diversion, it says a child diversion program is a program in which the child is required to participate. So that's where it starts. And then when you look under Section 2.3, it says that once the child accepts responsibility, the child shall be referred to child diversion, which is the only element of consideration there. But then when you move to Section 9, you have 4 elements of consideration. The child, it goes back to may be referred to, if the child accepts responsibility, if the child consents, if there's a prima facie case, if the victim consents. So we need to look at it holistically between all the sections and the different things that the sections are suggesting.
You see, this is the concern, Member Buchanan. It's not that I agree the child should go to child diversion, but you can't coerce. I mean, I know you see, I'm just thinking broadly at what, because of the experience I have. You see, I mean, what we do, what we're going to do, Ms. Eden, could you, we won't meet for another 2 weeks, okay? See if you can give us a draft just for Section 9. Sorry, let me...
Thank you. Chair, I just wish to remind the members of the committee that the context we have here is that we're reviewing an act.
Right.
And so my office has a particular mandate as to when we're released to draft.
No, I understand, but what we're saying, this is, I mean, just members would like to see what would a draft look like.
I understand that as long as there's an appreciation that it will not be construed as in any way limiting the assigned drafter when the time comes.
Admittedly.
Okay.
No. I think what members would like to see is if something could put in that gives a strong indication that once a child has committed a child diversion offense, the likelihood is that the child will be going to child diversion. Member Dixon.
Right.
Chair, I'm not understanding it sounding more complicated than it needs to be, and I just want to ask a question. If we have a child who is in conflict with the law and it is a child diversion offense, why can't it be that any child who commits a child diversion offense is referred to child diversion, and then the child diversion committee or entity is then required to do an initial assessment of the child. In that assessment, they would determine family circumstances, willingness of the child to participate. If the child at that point indicates, or there's indication that the child and family is not willing to go forward in this direction, then there is a different mechanism that kicks in through the court. Right. I'm just asking why that can't be it.
I think the confusion is caused by me. And the reason... no, and I want to defend myself. Firstly, I feel that where there's a victim, there is a need for the victim to be a part of the process. Because the victim, you can't ignore the victim. You can't ignore the victim consenting and understand, because the victim may want their pound of flesh. So you have to really work closely with the victim. No, the point I'm really making, you can't send the child to child diversion and the victim is out there lamenting that they have not got justice. No, let me finish. And that is why I have been a bit reluctant to say you just go ahead and ignore the consent of the victim. No, that's the first point. Minister Dixon, the second one is that, and the reason I'm saying why I have not fallen in line with all the members, the second point is, if there is not some figurehead authority that refer the child to child diversion, they may not feel that they have a reason to comply. And that is why I've said it is usually best if the referral comes from, say, a police officer or, you know, who... No, what we're really saying, if the referral is only from the parent, for example, you see the point? So, no, what I'm really saying, we're not going to the court. We say we're not going to the court, but the constable may well be the person who say, I'm going to charge you. Right. So that is a power. And if the constable, in fact, go ahead and charge, then the DPP or the prosecutor can refer. So there has to be a sort of coercive protocol that forces the child to comply. So those were two of the reasons why I felt I didn't want to say, from a child diversion, bam, child diversion. There need to be a process. No, there need to be a process for the referral. That's why No.
Chairman, I'm so sorry, but I'm not hearing what you're responding to in the chamber.
No. I was saying that the confusion was caused because of me. That's what I was saying, but I'm saying it was caused because I had these two concerns. The whole question of victim consent. And the second, there must be an authoritative position while the child feel that they should go ahead with the program. All right. I think we have made some headway. What we would want
Chairman,
I'm sorry. Go ahead, Senator.
If I could, well, on that very comment, we have made headway. What exactly is the headway that we have made on this point? I'm not clear.
No,
is the committee moving in a direction of supporting the position of a mandatory referral once it's a diversion offense, or is based on what you've just said, or is it that we're still on the fence as to whether or not it ought to be mandatory, or there are other things you have to consider, such as the victim's consent?
No, I think, Member Senator Shireen Golden, listen, my understanding is that my two reservations can be brought in by further discussion. So to the extent we say shall, but it also includes the consent of the victim, which can be obtained from discussion, I hope. Or the referral must come from the constable charging or about to charge, as the case may be. So when that is taken into consideration, I don't have a problem saying that for child diversion offenses, it shall, okay? For non-child diversion offenses, it has to go to the court. The court has to make a decision whether a particular offense for which a child has been charged that is appropriate for child diversion. Okay? So what we're saying, Senator Shireen Golden Campbell, is that we're going to ask the drafter, even though this is not a final position, to give us some indication of what was agreed on can be captured to replace Section 9. Is that my understanding? Right.
Well,
go ahead.
I forgive me, but I'm feeling still a little bit confused. We're asking the drafter to draft the provision to say what? What is the policy position that we are asking
to make it mandatory? To make it mandatory.
That diversion offenses will attract a mandatory referral to the child diversion program.
Yeah, that's correct.
Okay.
Which is the consensus. Sorry?
And in the case of an offense that's not a specified diversion offense, the judge will have the discretion
correct.
To refer?
That is correct.
Okay.
Because if it is not a child diversion offense, it may well be, as I pointed out earlier, that the child may be found with a toy gun or playing with toy guns or, have found with a bullet. And in those circumstances, you would want the court to make a decision that it could be referred to child diversion, because those would not be child diversion offenses. All right. Yes, Sandy.
Right. On the point of Section 9, Minister, before we wrap up, if that is the intention, just to also consider the reading of Section 9, which speaks to a child suspected, committed, charged with the commission of, or have been convicted. Right. So the committee, I invite the Joint Select Committee to also consider whether the Act is going to keep the references to persons who have been convicted and sentenced, because then if you look at Section 9 with the requirements to accept responsibility, there's a prima facie case, those would not be applicable to persons who have already been convicted and sentenced. So just on the point of Section 9, that additional consideration that is raised as to if we want to keep convicted, sentenced to for child diversion.
No, I don't think. Go ahead.
We went through this extensively. There are other aspects of it that I know the drafters have already probably removed it, but the language here, who has been convicted of, is now something that would be struck out, and there are other aspects of the legislation that will also not appear in the final draft because it's no longer relevant because that period has already passed.
The transitional was spent.
The transition was made, so all transitional language ought to have been removed or should be removed when that draft is presented to us.
Though you know, Member Buchanan.
Yes.
It may well be, we say that once a person has been convicted, it may well not be for child diversion offense, but have been convicted. Let us say convicted for robbery.
Mm-hmm.
Would you want to deny that child as a part of their rehabilitation, a referral to a child diversion?
It wouldn't be diversion. It would be a rehabilitation program, that DCS would actually factor in. And so there was a time when this legislation came to effect that judges had the opportunity to almost like a recall. It was like a recall mechanism when you read the act, that those children could be diverted, and the language says they're brought back to the court and a judge would say, I'm satisfied, and all of that. That's not, that's no longer in effect.
Right, but
your point is well made, you know, in that the way that some judges now interpret the act is that child diversion is a part of the sentence.
Yes.
Yes. They feel that when accept responsibility, you plead guilty, and then we send you to child diversion.
But that's what we're correcting now, Chairman. We're correcting that because that's why the language needs to be so exacting. But on this point, I know, or I would submit to the committee that certainly that wouldn't be diversion, that would be rehabilitation programs.
So, colleagues, we want to make, I agree, I must say, with what Member Buchanan is saying. If the person has been convicted, it means that they didn't get the opportunity for child diversion. So any other program to assist that will be a part of some rehabilitation. It could be restorative justice, could be something, but not, because child diversion means what it says. You're diverting the child away from the court process. I think that's...
But just to say as well, if the committee has the time, they could also look at the policy that informed the Act, which has a 4th tier. So they had Tier 1, Tier 2, Tier 3, Tier 4. And Tier 4 would have been post-adjudication, where they were looking at possibly using child diversion as a means of early release.
No, all right. So what we're going to say, Ms. Colgard, Sandaloo, is that those Tier 3 and 4 could be a part of a rehabilitation process, which could be within the Ministry of National Security. And, you understand? And they could utilize processes that similar to child diversion. But I think I agree that we make it crystal clear that child diversion means what it says. You're diverting people from the formal court process. Okay?
Clear, yes.
All right, I think we can stop here, and then we continue. Colleagues, remember now, We are going to continue this. No. No, you weren't here when the 24th and 25th are the two final days. And colleagues, the 24th and the 25th. By then we're going to have the matrix and we are going to finalize our recommendations. We have already made some recommendations already this morning. And we continue the recommendations. And then Wednesday and Thursday, the 24th and 25th of June, I'm going to urge all my colleagues to be there those times so we can finalize and a report can be sent to Parliament so that any changes in the next, by 2027, it should be operationalized, something like that, okay? I think we have done well, but we want to complete. Thanks, everyone. Can I have, sorry.
Chairman, a moment, please.
Sure.
And just to be clear, it is your intention to complete the overview because as I see it, we're only at section 9. We have another.
So we are going to combine it. I know we are going to combine it, Senator Shireen Golden Campbell, with the matrix, and we're going through clause by clause to the end.
Okay, very well.
All right, on the 24th and 25th. Okay. So hopefully by then I'm really hoping we will complete. And once we are complete, then a report will be drafted for our signature, and we don't present it to Parliament. I want to thank everyone for the really profound discussions this morning. Thanks members of the team from Law Reform, Ministry of Justice, OPC, and Parliament. And I hope the member upstairs who is from the Norman Manlin Law School, Ms. Janelle Smith, I hope you enjoyed the proceeding this morning. All right. Adjourn.
When the storm rages and the world feels shaken, remember our strength lies in unity. It's in coming together, sharing hope, and standing shoulder to shoulder that we find resilience. Every act of kindness, every word of encouragement builds a brighter tomorrow. We are stronger as one. Our courage, compassion, and hope will light the way forward. Together we rise. Together we rebuild, because hope is never lost when we stand united, because we are stronger together.
Remember, gambling is just a game. Choose to gamble responsibly. Set a budget, avoid chasing losses, and stop gambling when you reach your money limits. For gambling help, call RISE 888-991-4146. A message from the Betting, Gaming and Lotteries Commission.
Good day, students. Welcome to everyone tuned in to today's lesson. I am Alison Rowe, your Family and Consumer Management teacher. The topic for today is the family and the community. I hope you are ready to learn something new today in an interesting and informative way. Do you have your books and pens close by? If not, please do. You will need them. I will start off with the learning objectives of the lesson so that you are better able to understand and become engaged in what you are learning. The general objective is students should understand the relationship between the family and the wider community. The specific objectives are students should be able to 1. Define the term family. 2. State at least 4 characteristics of a healthy family. 3. Identify the different family types. 4. Outline the importance of the functions of the family. 5. List at least 6 family roles. 6. Explain ways in which the family can contribute to the community. And 7. Make effective decisions in order to promote, nurture, and support good relationships within the family and the community. The term family is a very popular word, which you have probably heard all your life. Families are common to everyone because of its value in society. Families form the basic unit of every society and community. You were born into a specific family, which makes you unique and special. But do you really know what a family is? Let us read this definition together. A family can be defined as a group of persons living together related by marriage, kingship, blood relationship, or adoption and sharing the same resources and responsibilities. Families are formed when relatives live together or when 2 people marry. Families may be big or small, depending on the number of children and adults present. What do you notice about all the families in your neighborhood? Are they the same or are they different? Well, if you look around your neighborhood, you will see that not all families are alike. Your family type depends on the different persons and the number of persons present in your household. Can you quickly make a list of all the persons living in your household? Be sure to write this down in your book for our upcoming discussion. Your family is one of many which will make up society, but regardless of the type of family you are in, there are certain characteristics that set some families apart in terms of overall happiness, health, and well-being. It is important to note that most families have some healthy and some unhealthy traits, and that no family is perfect. Every family has some good to build upon, as well as some things they really need to change. Let's pause for a moment to think about some of the things that take place in a healthy family relationship. Don't forget to write down your thoughts. If you thought about characteristics such as being loving and supportive, being respectful, spending quality time together, cooperation, providing security and a sense of belonging, or practicing open communication, you are on the right track. Great going. There are certain qualities that must be present in families if relationships are to remain healthy. Just think about your own family. How well do they display these characteristics? Is open communication practiced? Did you know that good communication is necessary to make one's intention clear? This is missing in some families. It takes speaking and listening for effective communication to happen. I am sure you will agree with me that listening when people speak shows that you care. If your family doesn't allow you to talk about your feelings, your experiences, or your needs, healthy communication isn't happening. On the other hand, if your family allows you to express yourself and is able to listen without judging, you have a healthy communication. Students, I encourage you all to take some time to talk to your older relatives and listen to them. Now, the concept of respect needs to be introduced at a very early age. Do you know why? Receiving respect from others is important because it helps us to feel safe and to further express ourselves. The secret of any healthy relationship is mutual respect. One important way in which you can develop self-respect is from the mutual respect learned in the family system. Think about what happens to children who are shown disrespect. Children who are shown disrespect becomes angry and resentful, growing up to be angry teenagers who make some bad choices in life. Again, I encourage you to make good choices and respect the rights of others. Healthy families spend quality time together. Quality time is spent physically, emotionally, and mentally connected with your family. Healthy families are serious about giving other family members their undivided attention. They have lots of fun together and laughter. This may be difficult to accomplish due to different family members' schedule. Students, try to remember the last time in which quality time was spent with you and your family. It could be watching a movie together, cooking together, playing a game, sharing a meal, attending a sporting event, or having a meaningful conversation. Healthy families delight in each other's company. No matter what your family is like, it is my hope that very soon you will be able to spend quality time with those that you love if you have not been doing so. Make some memories, tell a story, extend a hug, pray together, or share a laugh. I can guarantee it will bring health to your family. In healthy family relationships, there is also support, love, and affection for family members. Healthy families help one another when they need it. They also keep their promises, support one another, and show affection when they are together. A warm embrace, a squeeze of the hand, or a pat on the back are all gestures that speak love and support to one another. There is a saying that goes, "No man is an island." Do you know what this saying means? It simply means that everyone needs a shoulder to lean on in difficult times. Therefore, it is important to surround yourself with family or support and comfort in both times of joy and distress. You will need people to turn to for advice and encouragement when you face difficult times. My final point about healthy families is that they deal with problems in a calm, respectful way, allowing space for each other to talk and listen. There are times these relationships involve conflict which is a normal part of family life, conflict takes place in every family. When disagreements arise, they are settled in the correct manner rather than allowing tension to build up. In healthy relationships, these conflicts are resolved in a safe and respectful way. Now that you are aware of certain characteristics or qualities that must be present if family relationships are to be positive, let's take a closer look at the family types. Remember earlier in the lesson, mention was made that your family type depends on the different persons and the number of persons present in your household. Based on who you listed in your book, you will be able to determine the family type to which you belong after this discussion. There are several types of families, and it is important to know about them. Do you know the names of any family type? Family types include the nuclear family, the single-parent family, the extended family, the sibling family, the blended family, and the foster family. Do any of these names ring a bell? Let's start off with the nuclear family. The nuclear family has both parents living together. In this type of family, children may or may not be present. The children can either be born to them or adopted. This family is considered to be the ideal family by some people, as both parents are around. Next, there is the single-parent family, which has one parent living with the child or children. This parent provides for the child or children and sees that their needs are met. The parent may be male or female. Then there is the extended family. This family type is the largest of all families. It consists of different relatives living together and sharing the duties, financial, and living arrangements. This makes responsibilities in the home easier on all the family members as duties are completed by more persons. This family may include mother, father, grandparents, aunts, uncles, cousins, children, and grandchildren. With the sibling family, an older brother or sister is responsible for the younger siblings, perhaps due to death or migration of the parents. Do you know who siblings are? Siblings are brothers and sisters. The foster family is formed by adding children to another family. These children are either from abusive families, their parents may have died, or otherwise unable to take care of them. This new family takes care of them and is visited at times by social workers to make sure they are being taken care of properly. The final family type for today's lesson is the blended family. This family is formed from two separate families due to separation by divorce or death of one of the parents in the separate families. If both single parents marry again and both parties have children, then a blended family is formed. Can you tell the family type to which you belong? Great. Allow me to quickly check up on your progress so far in the lesson with these scenarios. Patrick is a 7th grader who lives in a small village with his little sister, his mother, and father. To which family type do you believe Patrick belongs? Have you thought about the answer based on the explanation earlier? If your answer is nuclear family, you are correct. Next, Jada is 25 years old and is solely responsible for taking care of her younger brothers, Troy and Kenny, ages 8 and 12, respectively. It has been 2 years since their parents had migrated. Which family type best fits this description? Do you have your answer ready? If your answer is sibling family, you are correct. Thanks for trying. Time to move on to the functions of the family. There are certain duties which every family must perform in order to obtain the greatest benefits from family living. These are generally called family functions. Although families may differ from one another, they are responsible for carrying out certain common functions. The family functions include reproduction, socialization, providing basic needs, transmitting the culture, conferring status by virtue of being a member of the family. Reproduction, also referred to as procreation, is an important function of the family. We are all products of reproduction. Its purpose is to increase family size either by bearing children or adopting them. Families reproduce to continue life and the family line, and so may have siblings and relatives by blood or adoption. Reproduction is important because young members of the family, like you, form a new generation of the family. Families have the right to reproduce so that the family grows, the population of the country is increased, and the family name is kept. Socialization. The family is where you first learn to share, how to relate, and how to treat other people. It is the first school of our life, and we learn manners and customs from the family. In the family, you learn how to interpret your surroundings correctly. It is where you discover how to draw the line between right and wrong, between good and evil. The family is the most important agent of socialization because it is the center of a child's life which guides values and attitude. The family has the major responsibility for the socialization of the children. The family also provides a feeling of belonging and sets standards by which you relate to other members of the family and the public. It provides training and care to prepare you for society. You learn how to fit in or socialize with family members. Everyone has basic needs, and it is the responsibility of the adults in the family to provide the basic needs for survival, which are food, shelter, clothing, and basic health care. These are the economic needs of the family and are important for the development of children. Love, education, and security are also basic needs of the family that must be met in order for families to survive properly in today's society. One of the most important needs of a family is shelter. A modern family needs a decent house with dedicated space for each member. Having access to basic amenities that a house provides, such as